Just by way of introduction, as was mentioned, I'm a lawyer with Soxapana and Associates, a law firm in Cambodia. I've been in Cambodia since 1994, and most of that time involved in property law. Initially, we were working with the first land law of 1992, working with the government on the drafting of the new land law of 2001, and then working a lot with the government on their registration programs under the new land law. And for the last 10 or 12 years, I've been with law firms here, acting for property developers largely, a number of the developments you see around town, such as World Bridge and Bangkok Lake and things of this nature. So the presentation that we prepared is, as mentioned, on the legal aspects of Borey development. So we don't look at it from the practical aspects of the developer. It's surely on what the law says. It's kind of short because there's not that much law. Okay, what's more interesting, I think, is the last slide as we get to it, which is kind of what the law does not cover. So when we act for our clients here, particularly the foreign investors, a lot of our work is to do with how to address issues that they're familiar with in their own countries that are not covered under the Cambodian law. So the issue here is not so much what the law says in Cambodia, it's what it does not cover. But I will start. This is general background information. So as you can see, the thing that's happened in Cambodia in particularly the last 7 years, is there's been massive growth. Since the economic crisis of 2007, there was some growth prior to that in the property development with Korean investment, with the Camco City projects, Tower 42 projects of that nature, which all came to a bit of a halt with the global economic crisis in 2007. It then started up again some sort of 5-6 years ago. So for those of you that are not from Cambodia, most of the development you see around town now has really come about in the last 5-6 years. And there's two aspects to that. One is, for the first time, there was a lot of domestic investment in property development. So your sort of Oxy World Bridge projects of that nature, the lake, Bangkok Lake, Phnom Penh City Centre. This is local money. This was a relatively new development in the property development field. And then, of course, in the last 2 years, we've seen a lot of money come down from China into property development. So what you see around town now it's been a massive growth over the last 4 or 5 years, particularly in the new high-rise building that's emerging, and Borey developments. So a lot of the Borey developments is largely Cambodian domestic investors. And what the law is still trying to struggle with and trying to put in place is what we tagged here as being co-owned buildings. Other countries, we refer to this as condominiums, apartment blocks, things of this nature. This is a relatively new area of Cambodian law. So the law for this came out 5-6 years ago, and it's still sort of being developed to accommodate a lot of these issues that were not addressed in the original law. The first thing we need to know is the licensing requirements to be a developer. This is a law that if you are a developer you need to know about, the Prakas number 965. And this law was brought into place to address a lot of issues that occurred just prior to the last financial crisis, when we had projects like Tower 42 that did not proceed. However, they'd been sold off the plan. So in other words, people had paid the money for those apartments that never came to be. So because they never eventuated, we were left with a situation of investors being left without the property they were investing in. So the government brought into place this law in an attempt to try and protect investors from a situation where a property development does not proceed. So they divided property developments into two types. Okay, the first type was where the developer themselves are paying for the development entirely from their own proceeds. Okay, there was not much that needed to be done about that in the law because there were no investors at risk. The second one, though, was the issue they were trying to address, and this is commonly called where you're buying units off the plan. Okay, so already the investor themselves, the future owner of the apartment, is being required to put up money before the building has been developed. and before the building is complete. They were the people that got hurt prior to the financial crash of 2007. So the government brought into law Practice number 965, and the second one, as you mentioned there, is where the funding for the development comes partly from the developer's own capital or entirely from the buyers. So where you've got people paying, your end customers paying, there's a special license required. And I'll go into detail a little bit about it. So the laws, if you're a property developer in the condominium space, this is the laws you need to know. Okay, the land law basically is the one that talks about property ownership rights. This is the law of 2001. This is the law that basically allows private ownership of land and property. Then what's important now for condominium developers, of course, is what we call the co-owned building law. So this is what, like I said elsewhere, it's called condominiums, apartment blocks, things like this. This is where one building will have many owners. Okay? And then the management of the housing development business. So this is the one then that talks about the licensing for the people building those condominiums. Okay, so category one. This is the one where the developers putting up the money themselves. So there's not too much in the way of requirements. You basically just need to be a company to start with. That applies to any business in Cambodia. So Cambodia is one of those places where if you do business here, you have to incorporate. You can't have sole individual business owners. So everybody has to incorporate. So you'll present your incorporation documentation. You'll present the ID of the applicant. And one requirement is that the chairman of those companies have to be Khmer citizens. Okay, so whoever's applying for the license has to provide their Khmer ID. Criminal record checks, insurance for the project being put in place. There's a minimum capital of 2 billion real for the company. You need to divide that by 4,000 if you want to know what that is in US dollars. And a detailed business plan. The business plan is a pro forma document from the ministry you can use. It's more about what your intended sales target is. It's not so much about the actual physical infrastructure of the project. So they're trying to get a sense of who you're selling to, how you're selling, things of that nature. The second category, though, is the one that has the extra requirements. So this is where they're trying to protect investors who are being asked to put deposit money down. So you need everything that a category 1 developer needs. In addition, there's these bank account requirements. So you have to establish a bank account with a commercial bank in Cambodia that's recognized, and it's a controlled bank account, so you don't have free access to that money. That's where you will deposit, or your investors will deposit their progress payments into that bank account, and that's not something that's controlled by the developer. The second account you need is a separate account where you keep and you maintain a deposit that's equivalent to 2% of the project value. So the first account, the developer's account, is there as you finish phases of the project. The first phase, which is generally the foundation work, has to be paid for initially by the developer. You can then take money in from your investors to pay for each phase. As each phase is completed, you will get a quantity surveyor or an authorised surveyor's report confirming that you've completed that phase, and then you can draw down that money that your investors put in for payment of that phase. So that account is controlled through government regulation, and it's to be used on authorised and confirmed completion of each phase of the project. The 2% deposit will remain in the account until the completion of the project. So this is what separates the two types of developers. Okay, the first developer, where you're paying for it yourself, there's no requirements about where you keep your money or anything of that nature. The second one, though, is the government's effort to protect investors from losing their money for projects that do not complete. The licenses themselves are issued by the Ministry of Finance. The term, meaning the length of the license, depends on your project. So this is all again part of the plan you'll submit to the government. they will work with you on that. So if you're developing a Borey and it's going to take you 4 years, okay, you will get a 4-year license. That's the general concept. But if the government themselves will come in and make an assessment of how long they think the license is necessary to be issued for. The government will take away the license if you do not commence the project within time, or if you fail to meet any of the legal obligations required for developers under the law, then the government has the right to remove the license. The construction permits, which is what, once you've got the developer's license, that gives you the right to start advertising, to start the project, things of that nature. You still have to apply for the usual construction permits on any construction in Cambodia. The same will apply even though you've got a developer's license. Depending on the size of the development is where you will apply for your license. There's exceptions to this. For example, if you're constructing a petrol station, well, you'll be getting from the Ministry of Land Management, even though it's a small project. But generally, where you get your license from depends upon the size of the project. Other permits. So once you've got your developer's license, you've got your construction license, and you've commenced. Before you can actually start building, you need to get a site opening permit, which is fairly routine, but it has to be obtained before you can start to break ground, so to speak. At the end, you will be getting a site closing permit and what they call a certificate of compliance. In reality, the government does not issue certificates of compliance. The reason for that is a certificate of compliance is where the government officials are going in, they're looking at your building, they're looking at the original plans, and they're confirming that it was done in accordance with the architectural designs and all the various physical aspects of the plan. They don't have the actual capacity to do that, so they're not actually issuing what's meant to be under law certificates of compliance. What they are issuing is a site closing permit, which is basically just saying, we agree the project is finished, and this is a confirmation of that. Okay, so they're fairly routine again. The other permits you may need if you're demolishing anything existing on the site or renovation, there's a separate permit for that, but that's, most projects here are greenfield projects. They're on an empty piece of land, so they're not that common. Once you've built your building, particularly when we're talking about condominiums, the aim of the whole project, of course, is to sell these to end users. So I've got an apartment block with 60 apartments. I need now to get the ownership of that from me, the developer, to my end user, and there could be 60 of those, one per apartment. So in order to do that, we have to make an application to the Ministry of Land Management, the cadastral office. The required documents is the same documents that are required for the transfer of any property. What's missing here, though, is how you get the first strata title deed. So what will happen is, once you've completed your project and you've got the closing certificate, at that stage, all you have is one title deed for the land that you built the project on. Okay, so once you start a project, there'll be one title deed for the 1 hectare or whatever your piece of land is. You now need to convert that to 60 different title deeds for each one of your apartments to transfer to your buyers. So what will occur is that you will submit the site closing together with the architectural designs. The ministry will then take your one title deed and basically destroy that and replace it with 60 title deeds that correlate with each one of your apartments as per the drawings on your plan. So you will then receive 60 title deeds. Each of those will go into the names of the various parties that are owning it. So you'll be submitting the identity documents of each of those parties. Or as a company, it's the same thing, you'll be submitting the company documents. The Vente Definitive, which is the word for a transfer document. So this is where it's transferring from you as the owner of the title deed of the land to your buyer. And other documents required by authorities. This usually will be the case where the company's involved. They'll want shareholder resolution, directors' resolutions, things of this nature. But with that, you will then end up with title deeds in the name of your buyers. There's a 4% transfer tax that applies to all property transactions, and from our experience, the process takes approximately 2 to 3 months. Okay, that's from completion of the building until the title deeds are issued in your customer names. Okay, this slide. One of the issues that's still a little bit unclear in Cambodia is this issue of private versus the public areas, the common space, the common areas in condominium developments. So the private area is the areas under the private exclusive use, so that's the actual apartments, apartment number 1, apartment number 2, etc. The common areas are the areas which are common to all of the tenants equally. So this is your hallways, your gardens, the rooftop, the common areas that we're used to, that everybody has equal access to. And for developers, this is where your sinking costs come into effect, your monthly, your expected monthly payments from your buyers to maintain these common areas. So the Cambodian law recognises the two. However, these are the problems. Okay, so we've done many property developments on the legal side over the years. The problem is that the law, when it was written from the perspective of a residential apartment complex. Okay, so the Cohen building, when they thought of that, they were thinking of the typical Cambodian Cohen arrangement, where it's just a number of apartments, each individually owned by individual owners. The idea of the SOHO, the small office, home office, the malls, like your Aon Mall, etc., residential complexes, things of this nature were never considered in the law. So, there's a number of problems here. One we struck is measurement. So if you're a developer and you're selling, you're basically selling on a square metre basis. So your plan, your map of the apartment floor plan, or set out the per square metre size of each apartment, you'll be multiplying that by whatever, and then coming up with a purchase price. There became a big issue as to where you measure those apartments from in terms of joint walls. Okay? So the Cambodian law says that a wall, the ownership of a wall is jointly owned by the neighbouring apartments, and when you measure the size of an apartment, the private area runs from the middle of the wall, okay, across. The problem is on walls that adjoin apartment on the other side, it makes sense. What developers were trying to do though was maximise the size to boost the purchase price. And so when it came to non-adjoining walls, so walls that adjoined hallways, for example, or the outside walls, what they would ideally see as being the situation is that entire wall is owned by the apartment owner. So he's paying for that wall. So they're measuring from the outside of that wall. The Cambodian government, when they put the closing certificates, when they're issuing the title deeds, they're measuring everything from the centre of the wall, regardless of whether it's an adjoining wall or whether it's an external wall. So we've managed to convince the cadastral lately that they are agreeing now to measure the non-adjoining walls, the external walls from the outside. But you'll find this is going to, if you're a developer, this is something you're going to have to negotiate with the cadastral before you get your title deeds issued. Because the problems we struck was when it came to payment. So on the plan, on the advertising plan, the clients are told their property is, 65 square metres. When they get the title deed, it's slightly less, because the government was measuring it from the middle of the wall. And so they were asking for an amendment to the pricing. It became some big issues, particularly on properties the size of the bridge, where there are many, many apartments. So it's something, if you're a developer, you need to get clear from the very beginning as to what your title deed size will be. Otherwise, you're going to have lawsuits from your buyers on breach of contract. The parking, this was our biggest issue. So what the law doesn't accommodate, particularly in mixed-use developments or actually all the residential developments, is the car parking space. Where I come from in Australia, and probably a lot of the countries you may come from, apartments in Australia, each apartment has designated to it one of the car parking spaces, it forms part of the title deed. Okay? So if I own an apartment on the 7th floor, on my title deed on the back is a map of the car park area on the third or whatever floor it's on, and I may be car park space number 7A. I physically own that car park space. Okay? And in places like London and Tokyo, this is a massive business actually to invest in car park spaces because the value is quite astronomical on the Quest. So it's a very, very valuable aspect. The problem in Cambodia is the law does not accommodate that. So when some of our earlier developers came in, this was the expectation that they could offer up to their buyers a car park space. It adds enormous value, as you know, in city centres to an apartment. When we went to the government to issue title deeds, they would not issue it for the car park space. Okay? The reason is that in the land law, as you showed earlier, it speaks about common areas in the co-owned part of the land law. And it references car parks as being an example of common area. So the ministry officials at the Ministry of Land read that and took that to mean that car parks are common areas regardless. When the law was drafted, that wasn't the intention. They were just giving examples of what could be common areas, gardens, car parks, roofs, etc. It doesn't mean it has to be. We have this problem right now with the Ministry of Land Management, so we're working with it, particularly for the bridge project. The position they're at the moment is initially they would not issue a title deed at all for the floor that has the car park. So it just remained common space, okay? It has no title deed. Now they're willing to issue a title deed for that particular floor, but one title deed only. So yes, it will be privately owned, but it will be privately owned by the developer. And the developer, what we've done in those scenarios is when the original proposition to the buyer is that they can get access to a car park space, but it's actually done almost as a leaseback scenario. So we've put it through the body corporate rules, where the owners themselves, because it's common area, although that whole car park space is control of it is given to the body corporate. The body corporate in turn allows the individual owners to exclusive use of certain car park spaces. Okay? Without that, it becomes common area and nobody can get exclusivity to any particular parking spot. And nobody can deny anybody, any owner, access. So the progress at the moment is that the ministry is willing to at least issue title deeds now on the car park floor. So if you're developing a development that has, this is one issue you have to get straight from the beginning, okay? Because as you're selling to your buyers, they need to know what is their rights vis-a-vis car parking spaces. So the law doesn't quite accommodate it. So the ministry, though, at the moment is willing to issue title deeds, but they'll do it in the name of the developer. If you don't say anything from the beginning, they just will not issue a title deed. So you'll end up with a situation where it will be classified as common area. Common area, nobody owns. Okay? Everybody kind of owns equally, but the developer loses control. Okay? So if you're developing, beware at the very beginning to address the issue of car parks. The last point is what the law never accommodated. As I mentioned, when they wrote the co-ownership law, they were thinking residential apartment blocks, and that's it. Okay? Of course, a lot of what's happening now in Cambodia is mixed use. Okay? So we've got properties where there's both residential and commercial. At the moment, the law says that title deeds shall be issued on residential units, because that's what they had in mind when they wrote the law. So they're refusing at this stage to issue title deeds for commercial units. So it's a problem we're dealing with the ministry, again, typical of, ones like the bridge, the peak, etc. This is where you've got commercial ground floor, residential above. For the residential is okay, we can get title deeds issued. For the ground floor, the ministry is refusing to issue title deeds. And a lot of work's been done now, they're agreeing to do that. But again, this is something that you need to be clear on if you're developing. There's a difference under Cambodian law between residential and commercial. Residential is catered for in the law, commercial is not. So if you intend to use any floor for commercial premises, you've got to be clear from the beginning regulator with the cadastral around title of those. Otherwise, you're not going to be able to sell them. So when you see the malls here, like Aon Mall and whatnot, these are just on one title deed. Okay? There's no ability at this stage with commercial/retail. So at this stage, nobody's asking. But if you're going to develop anything that's commercial based, you need to be clear from the get-go with the government as to how you're going to title this. Otherwise, you'll end up in a situation where you'll get a rent, but you won't have any title to pass on. So these 4 issues are the ones that we've been dealing with for the last 2 years or so. Is the amount of development has progressed. These are issues everybody is coming up against. Sort of one by one, we're getting them dealt with, but because it's not in the law, it's important that you address it on a one-by-one basis with your developments going forward. So that is basically, that's us. That's me. That is basically the situation at the moment in terms of the legal framework around property development. So, like I said, what we're waiting for coming forward is more clarification to address the issues that are not currently addressed, which are those 4 here. So we're hoping in time the government will start to put down in writing, particularly around titling of what we see as not being common areas and they see as being common areas, and titling of commercial properties. But other than that, the framework is fairly limited. It's just a requirement of getting the developer license, the construction license, and then the closing license, and then ensuring that you've got your title deeds converted from a single title deed into individual title deeds for your properties. And on the commercial, on the car park, you're going to have to address that on a case-by-case basis.